Moving on. The bench of a Bombay High Court has said following or abusing a woman is not an offense, or it's not outraging of modesty. I mean, when I say it's not an offense under outraging of modesty section of IPC, it may be annoying acts, but does not constitute offense of outraging the modesty under IPC section 354. This, even as a college student, filed a police complaint alleging that a man followed her regularly, stalking and abusing her, and once even pushed her or shoved her. Now, so how do you really define what is annoying and what is outraging the modesty of a woman? Most importantly, has anything changed under the Bharatiya Nyaya Sanhita? I'm being joined right now by P.K. Jain, who is a former additional DGP for Maharashtra. Thank you very much, sir, for joining us. You know, even as the court has said this, sir, and let me just try and break this down. We'll get into what the court has said in a brief, but legally, what is it?
See, this is very unfortunate that the courts in India have been passing different kind of judgments and expressing different kind of opinions on matters like this. You know, if you remember some time back, also there was another High Court judgment in a similar matter where there was a lady judge who had passed a very controversial kind of a decision in a similar case of molestation. So I don't know. I mean, if following a girl and pushing her and verbally abusing her and all that is not an offense, which tantamounts or which is outraging the modesty of a woman, what else would it be? I mean, in this case, a person has been following this girl.
So are you saying, legally speaking, sir, and I'm trying to understand, I've called you here because to try and legally understand, because, you know, we can't really question the courts as such, but I'm trying to legally understand the position here. If you're following a woman, which is nothing short of stalking, if you're abusing her, if you're shoving her, is this part of outraging the modesty of a woman? I'm even sorry I'm asking you this question, but I just need to, we just want to be clear legally what's the position.
See, legally, my stand is very clear. This is a case of molestation. This is certainly a case of stalking. This is certainly a case of molestation of that girl. And there's no way that the accused should have been let free on this. As a police officer, I would prosecute, I would file a case, I would prosecute the person concerned. And in more cases than not, this will stand the test of time. This will stand all the evidence that is required in the court. I see no reason why the Honorable High Court should have passed a judgment like this.
So, are you then saying that molestation and stalking is also something that would be tried under under Section 354 of outraging the modesty of a woman?
See, there are three sections in IPC. One in the old IPC, one was 509, where it was actions and gestures. 354 is actual touching and molesting a woman and outraging her modesty. And the third one is the sections of rape under Section 376. So there are three different sections in the IPC.
So is it that the police in this case chose the wrong section? Is that something to do with this?
No, absolutely not. In this case, he was following this girl and subsequently he pushed her around, he jostled her, is something which would certainly fall under Section 354. There's no question of 509 here. 509 is when there is no physical contact, when the person only passes remarks, or maybe he ogles, he makes some obscene gestures, etc. would be probably 509. But in this case, the moment it becomes physical, it becomes a case under Section 354. And a step beyond that is Section 376. I have no confusion in my mind. This is a perfect case where Section 354 had been applied and where it should have been seen through. I mean, you can understand that the person, the accused in this case, has gone through the conviction at the lower court and then in the sessions court, and it is only in the second stage of appeal that he got some relief from the High Court. When I personally feel that the High Court should have examined the facts of the case and upheld the conviction awarded to this fellow. I mean, there's no reason why the High Court should have taken or would have taken a contrarian view. I'm absolutely clear in this.
Sir, allow me to read out one sentence, and this is what is being quoted. act of following, abusing, annoying, maybe annoying or offensive, but it's not shocking the decency of a woman. Is this the right interpretation of the section?
Absolutely.
And I'm not really going on the
Absolutely.
court. I'm just trying to understand, is this the right interpretation of the court? Is it right to say
what
that
has
act
happened
of
in
following or abusing or maybe annoying or offensive for a person, but it will not be shocking the decency of a woman? Is that correct to say?
I would not agree with the court on this. I would, as a police officer, I would like to register a case under Section 354. There is a physical contact. He has tried to assault this girl.
All right.
And this assault has also come out of his frustration of this girl not probably giving in. That is why there is no reason why Section 354 in this
She
case
said
would not
he's
have
been
been applied.
repeatedly following
It has
her,
been rightly
which is
applied.
repeatedly stalking.
See, repeatedly stalking, as I said, would probably fall under, it could fall under, broadly under 354, but it would fall under 509. Stalking a person, then maybe making some threatening gestures, etc. Other sections would be attracted. But in this case, it has beyond following and stalking, it has gone to the extent of assault. And assault with the intention of what? Because the girl did not give in, and the accused got emboldened, and finally he went to the extent of assaulting this girl. So everything would certainly fall into place for this section to be applied. And he was rightly convicted by the lower court. And probably in the first court of appeal, that is the Sessions Court also, this conviction had been upheld. It is only in the second appeal that this conviction got diluted, and he was set free, which to my mind is not the right course of action.
Absolutely. So, and just a last minute on this, sir. I mean, we've been discussing IPC, but under the Bharatiya Nyaya Sanhita also, all of this stays. Nothing has really changed when it comes to this, hasn't it?
I'm sorry, I didn't get your question.
Sir, I mean, we've been discussing IPC sections, but under the new revised criminal laws that have been passed in the Parliament, the Bharatiya Nyaya Sanhita, these sections still stay. This has not changed, right?
I would not be able to comment on that. I have not gone thoroughly into the. I have not read it completely, but I'm sure that whatever has been discussed in the Parliament, all the offences against women and children have been given a lot of importance.
Right.
I'm sure that these sections would be kept in the new IPC, maybe under a different wording, but the sense and sensibility would not change.
True.
So there's no way that the women.
You're right, sir. In fact, from the research
molested.
that we have been able to see, the sections for these particular crimes have been retained as it is. Thank you very much, sir, for joining us on this very important issue. We've tried to break this down. We have not gone into the legality of it, but we're trying to understand, what really is this in the criminal parlance? What does it mean as a woman? It's important for us as a society as well to understand this. Thank you very much, sir, for joining us.
Thank you very much. Namaskar.